Okay, this video summarizes some of the key concepts behind RICO, or the Racketeer Influence and Corrupt Organizations Act. And it's been in the news lately because a number of organizations are being prosecuted under RICO. So it's worth a few minutes just to understand the basic concepts behind this statute. The concept was to give prosecutors a more powerful tool to go after the organizations that were conducting illegal activities. So it was originally focused on organized crime such as the mafia. And the problem prosecutors had was that if organized crime ordered, for example, a hit and hired a hitman to perform an execution, prosecutors could get the guy who actually bought the gun and fired the shot and executed the person because there was ample evidence with the gun and the ballistics and the body, etc. But they were having difficulty getting the organization that ordered the hit. So they went to Congress and requested additional enforcement authority, and RICO, the RICO statute is the result. And as all the criminal statutes, is embodied in Title 18, and these are sections 1961 through 1968. So this was enacted in 1970, and again, it's designed to give prosecutors additional legal grounds to charge organized crime with criminal offenses and civil causes of action. And the idea is to allow the prosecutor to get not only the perpetrator of the act, but also the organization or the syndicate behind that act that ordered or assisted in that illegal act. So that is the concept of it, and it includes both criminal and civil violations. So a key term in the statute is what we call racketeering activity, which is defined in this section 1961. And you can see I've highlighted in light blue briefly some of the just a number of the provisions, not all of them. It's kind of overwhelming to work your way through this. It's kind of like reading the definition of security in the 1933 Securities Act. It just goes on and on. So there are a lot of listed violations here, and the concept there is that if an organization engages in two or more of these racketeering activities, then it is deemed to be a criminal enterprise. So at least it's a pattern of racketeering activity requires at least two acts of these activities that are listed in this section. So and this is the prohibited activity. You know, if you're engaged in a pattern of racketeering activity, this is the key phrase in the statute. And it's worth noting that aiding or abetting is also a violation, which means that one who aids and abets the commission of a federal crime is also treated as if he had committed the crime as the principal, and he can be charged under RICO. So, you know, if you buy the bullets for the gun that's used to kill someone, then you've aided and abetted in that commission of that act. And, you know, from the standpoint of the Department of Justice, you can be charged with the murder as well. And, you know, this comes out of the U.S. Department of Justice Manual for Federal Prosecutors, page 27. So this is their guidance, this is their position for the U.S. attorneys as to how to prosecute these crimes. This article here in the Villanova Journal provides some nice background of the RICO statute, which was drafted by Robert Blakely. He's still around. You see him on television once in a while, and he explains the concepts behind the statute. I briefly want to mention wire fraud. The wire fraud statute, it's based on the mail fraud statute. So we've had the mail fraud statute for a long time, which basically says that if you use the mail for the commission of an illegal activity, then you can be charged with mail fraud. So, and mail fraud means postage, meaning envelopes with stamps, or what we've called a snail mail sometimes. Obviously, the world has changed a lot, and there's a substantial amount of fraud committed through technological advances. And so this is the wire fraud statute in Title 18, Section 1343. And it's basically based on the concept of the mail fraud statute, but it means, again, these activities which are conducted over wires, radio, television, internet, email, Skype, whatever. So it's very common to see violations of the wire fraud statute in these criminal prosecutions. So one of the more famous RICO cases, civil cases, involves the tobacco industry, which was filed in 1999 right here in the District of Columbia trial court. And it was filed against the major cigarette companies, alleging they had engaged in a massive 50-year scheme to fraud the public regarding the health and safety and the use of cigarettes. And that litigation went on for 7 years, and in 2006, indeed, the judge did find that the facts supported a conclusion that the companies engaged in in racketeering conduct and were racketeering enterprise, and that they coordinated significant aspects of their public relations, scientific, legal, and marketing activity in furtherance of a shared objective to maximize industry profits by preserving and expanding the market for cigarettes through a scheme to deceive the public. And so this is a pretty major case against tobacco companies, and the complete story is here in this, and the findings are here in this web link on the Justice Department website. But just to touch on a few points in the district court's opinion, it's stunning to see what the court wrote. It says here in paragraph 1758, defendants have repeatedly made vigorous and impassioned public denials before congressional committees, advertisements, national print media, on television, that neither smoking nor nicotine is addictive, and that they do not manipulate, alter, or control the amount of nicotine in the cigarettes they make. The findings of fact provide overwhelming evidence these statements are false. Paragraph 1763, in sum, the evidence is presented is overwhelming that the tobacco companies have, over the course of many years and time again, and with great self-righteousness, denied they manipulated the nicotine in cigarettes so as to increase addiction. These denials were blatantly false. Concerning marketing to youth, trying to build a new market. The evidence is clear and convincing and beyond any reasonable doubt, as paragraph 3296. Defendants have marketed to young people 21 and under while consistently, publicly, and falsely denying that they did so. Paragraph 1397. In response to a mountain of evidence to the contrary, defendants claim that billions of dollars have been spent on cigarette marketing serves the primary purpose of retaining loyal customers, brand loyalty, and the secondary purpose of encouraging smokers to switch brands. The activities were intended to bring new, young, and hopefully long-lived smokers into the market in order to replace those who were dying largely from the use of their product, or those who were convinced to quit. They spend billions of dollars every year in their marketing activities in order to encourage young people to try and then continue purchasing their cigarette products. In the face of the evidence, defendants have denied over and over with great self-righteousness they have marketed to youth, and the facts clearly showed otherwise. They coordinated a well-financed, sophisticated public relations campaign to attack and distort scientific evidence demonstrating the relationship between smoking and disease, claiming the link between the two was still an open question. They ignored massive documentation in their own internal corporate files from their own scientists, executives, and public relations people, that, as their VP admitted, there was little basis for disputing the findings of the 1964 Surgeon General's report that smoking was hazardous to your health. So that case is pretty well known, So now a more contemporary application here is the FIFA indictment. Uh, FIFA being the well-known soccer uh, federation promoting soccer worldwide that's headed up by Sepp Blatter. It's pretty well known that in just this past May 27th, FIFA officials were named in the indictment. They were meeting for their annual meeting in a five-star hotel in Zurich, Switzerland, and they were raided, and the Swiss authority arrested a number of them because the U.S. had issued an indictment for their arrest, charging the FIFA officials pocketed over 150 million in bribes and kickbacks related to decide who would televise soccer games, and this is where the money is in soccer, who gets the television rights, where the games would be held, and who would run the organization overseeing the organized worldwide soccer. And then once that was issued and they were arrested in Switzerland, other FIFA officials around the world, coordinating with Interpol, ordered the arrest of other indicted officials. 3 were arrested in Argentina under the orders of an Argentinian judge. So this was pretty well publicized. And when you look at the history of this, it started really from a tax evasion investigation. A former FIFA official, Charles Blazer, was being investigated for failure to pay taxes in the United States. And the Internal Revenue Service is investigating it, and they find massive failure to report income. And so this is the incentive for someone like this to start talking. And Blazer basically says, look, I can tell you all kinds of bribes and kickback stories and criminal conduct about FIFA if you give me leniency on this tax evasion. And so when he starts talking, this is when the government learns about this extensive culture of bribes, kickbacks, money laundering by FIFA officials. And this is all per New York Times story just this past May. So this is how this started. And you can look at, this is the indictment, and it's online. You can read it. It gives you a fair amount of detail about what's happening. Here's a Trinidad businessman, defendant Jack Warner, diverted a portion of the funds into personal accounts by laundering the funds through intermediaries. Caused approximately 1.4 million of 10 million to be transferred to an individual businessman. So this it's an ongoing investigation. There's more to come, and it's worth taking a look at an indictment. This is a public document. It's confidential when it's being presented to the grand jury, but now it's public. And Sepp Blatter, who heads up FIFA, was not named in the indictment, but this is all swirling around him, and I'm sure he's quite concerned about his future. He's made several trips to Russia, and it's a difficult time for both the organization, the sport, and Sepp Blatter. Interpol, we've mentioned this several times. It's not a police organization per se, with arrest authority, etc., but they are there to help coordinate law enforcement among international police organizations, among the state police organizations. So they will help give notice about arrest warrants issued by countries. Here's the notice just this past June about issuing red notices for former FIFA officials and executives wanted by the U.S. authorities. And of course, once they're arrested, then they are extradited to the United States for trial. And they fight the extradition, and the extradition is based on treaties among countries that we agree to expedite those for whom we've issued an arrest warrant. So this is an ongoing story. Senator Blumenthal, this has gotten attention up on Capitol Hill just this past July. Senator Blumenthal issues an opening statement. The first sentence is stunning in that it says, "The fact of the matter is that what has been revealed so far is a mafia-style crime syndicate in charge of this sport. My only hesitation in using that term is that it is almost insulting to the mafia, because the mafia would never have been so blatant, overt, and arrogant in the corruption." So he he thinks even mafia is more subterfuge in their conduct than FIFA. So this is an ongoing story. Another case that has developed involves the oil companies. Just recently, New York Attorney General for the state of New York issued subpoenas to ExxonMobil, demanding documents to review for conduct arguably similar to what happened with the tobacco industry, meaning that the investigation, there's no charge or indictment of any sort, but that the investigation concerns the oil companies and climate change, and the question being whether they engaged in conduct to cover up climate change as a result of their fossil fuels, where they sponsored research to promote results that try to show there is no climate change, or there's no link between climate change and fossil fuels. And this is an investigation that's just started recently, and but is another example of RICO, most likely a civil RICO case that is being instituted. So, all right, that concludes what we have on RICO.